Blog Talk Radio. Welcome to Women Who Rock Investigates, an affiliate of Women Who Rock with Success. We report case studies in the areas of policy and government, medical malpractices, health pandemics, biotech and fracking, global climate change, prison, and police reform, and more. Our topics are covered around the latest breaking news reports in the U.S. and around the globe. We can be heard on Spotify, Google Play, Google Podcast, TuneIn, iTunes, Podbean, Airtime Pro, and SAM Broadcasting radio stations, and more. Our hand-picked experts on the show provide credible information from their fields of experience. Join us on Thursdays at 10 a.m. Central Standard Time as we discover the latest in news reports. Now join us live in the studio with our show host, Mrs. Diane Winbush.
And good morning and welcome to Women Who Rock Investigates. Thank you so much for tuning in with us and joining us on this morning. And the first thing that we want to say before we get started is we want to give a shout-out to all the veterans and soldiers on Veterans Day. So happy Veterans Day to all of the men and women that have contributed to our country and other countries as well. So we thought about doing a continuation on the topics of your rights as a power of attorney and advance directive. And so we felt that this topic was much needed continually, and we're going to kind of get into it a little bit today so we can learn a little bit more. Last week, one of our guests was Attorney Rebecca Goldfarb, and she's on with us today as well. And so today we have another attorney that is joined in with us, and she is none other than Laura French. So we want to give her an introduction and welcome her to the podcast. And so first we want to get both of the attorneys to introduce themselves, share what is it that they do in their practices, and then we can go from there. We'll start with Laura first.
Thank you, Diane. Hi, Rebecca. And I just want to echo what you said. Very happy Veterans Day to everyone who has worked to secure our freedom, including some of my family members. So we thank them for their service. So my name is Laura French. I am the mom lawyer, the founder and owner of French Law Group, located just outside of Athens, Georgia. I have been practicing for 26 years at this point. Okay. And my practice really focuses on estate planning, elder law. How do we help you plan and protect yourself both while you're alive, but also make provisions for your family after you're gone?
Okay, great. And so do we have Rebecca on?
Yes, good morning and happy Veterans Day to everyone. And hi, Laura. I'm so excited to meet a fellow estate and elder law attorney in Georgia because I don't know anyone there, so I'm excited. So I am Rebecca Goldfarb, and our firm is Goldfarb and Liu with my wonderful partner, Din Liu, and we practice estate planning and elder law as well.
Okay, great. Straight to the point. So we're going to get started with last week we talked about, so let's go back and review. Last week we talked about power of attorneys, and then we also went inside of the prison institution as to how this is valuable and important for family members with advanced directives and power of attorneys as well. And then we also shared a little bit about banks, and Rebecca also shared with the audience as to how banks also can have their own power of attorney forms, and so that can cause a little friction with individuals that are trying to get legal documents signed and what have you. So we're going to start with Laura, and we want you to be able to share with the audience the definition of estate planning.
That's a great question, Diane. And Rebecca, you probably experienced this as well, but I think sometimes the general public has a misconception in terms of what estate planning really means. The way I use that term is we take a look at who you are, what's important to you, what you own, who you love, and how we put all of those things together in a legally recognized way. That's going to include anything from a will to a trust. It could include asset protection planning and in many instances, powers of attorney for either financial or medical decision making can sometimes be as important, if not more important, really depending on the situation. So some people get confused and think estate planning is only for people who have a certain amount of wealth or a certain type of asset, but estate planning really is for everybody.
Okay, great. Okay, so would you like to elaborate on that, Rebecca, or we can go to the next question?
I agree with Laura, and I always say that a successful estate plan should do three things. One, it should honor your wishes. Two, it should avoid court. And three, it should maintain family harmony. So we use these set of documents in order to be able to do that both during incapacity and after someone passes away.
Okay, great. So we shared some scenarios last week, and we're going to share some live scenarios as well as today, because individuals may face different legal practices in different states. And so the first scenario, and this is going to go to Laura and Rebecca. And so it was an individual that passed away. And so what happened was he had a wife and he had several children. And so the medical malpractice come from a legal drug that I would not like to, I don't want to, be bashing any drug pharmacist or company or anything like that. So anyways, it was a settlement that was given. However, the individual, that was deceased, he did not have a will. So it went immediately to his wife and his adult children. So we want to be able to go into that, and I think we kind of touched on it a little bit, but it was a little bit different on the last week's segment that we had, simply because of the fact a malpractice suit was not involved. So some individuals don't even know their rights, and certain states may not even honor adult children after their loved one has passed away. So I want Laura to be the first one to be able to expound on that, if she could be able to, because a lot of times, as I stated, an individual may not even know their rights. They may not even know what they are entitled to, because the children in this scenario was not even aware of what they were entitled to until of course, they were contacted by a legal representative.
That sounds like a very sad situation, and it's similar to things I've seen in the office, and I'm sure Rebecca has as well. As a general matter, every state has written a will for you and for me. It probably doesn't say what we want it to say. And it sounds like that might, be the issue with this family who unfortunately lost their father and their husband. So in my state, I'm in Georgia, but I've also taught wills, trusts, and estates in law school. So I'm somewhat familiar with other states as well. But in Georgia, there would be a percentage going to the wife, and then there would be a percentage split among the rest of the children, whether they are adults or minors. If there are minors involved, then that, of course, can bring in a secondary court process, conservatorship in my state, to make sure that that money is adequately protected and handled for those children. An additional issue that can come up that could defeat the rights of the children is spousal support. In Georgia, that is called years support. We have a law that is pretty unique compared to other states in the union. But spouses often have higher or superior claims to an estate if adequate planning is not conducted prior to death. And those claims sometimes can defeat the rights of the adult children. Very fact-specific, of course, depends on what state you're in.
Okay, Rebecca?
Absolutely. It's similar here. Is Georgia a community property state, Laura?
No, we're not.
Oh, okay. California is a community property state, which essentially means that when you get married, half of everything you earn is automatically goes to your spouse. But anything you bring to the marriage is considered separate property, and anything you inherit during the marriage is considered separate property. So we split it between a spouse and children based on if it's community property or separate property, kind of how that goes. And then if we have minors, then there has to be a custodian to handle and supervise that money until they become 18. Which is, a reason that Laura and all of us estate planners want people to do trusts so that you know the person who's managing that money and you appoint that person before you pass away to be the person to manage the money until the children are of the right age, which is usually not 18. But that's the default that Laura was mentioning, that these plans called intestacy are set up for us if we don't plan for ourselves.
Okay. And so with the same scenario, and like I said, I listen to a lot of people, and so that's what I do. And so that's the reason why I bring the scenarios to this case study podcast. So with the same scenario, even though he did not leave a will, but he still has a home, which is also property, intellectual properties, but he did not leave no one's name on the property but himself. So how would that work in regards to those that are left behind? After
Which
the wife
state
has
was
passed
that?
away, Tennessee.
Okay. I don't know Tennessee. You're closer, Laura, than I am.
Yeah,
if you know anything about it.
So I don't know Tennessee law specifically, but
Okay.
Tennessee is going to have a statute on the books, the laws of intestacy, that dictates where the property goes if somebody dies without a will. And in my state, we look for a spouse, we look for children. Those are sort of the obvious relationships. Then we go further out, descendants, parents, siblings, nieces, nephews, cousins. So there's kind of a pecking order that a state will set up, and you really compare the family tree to the state statute to figure out who is going to receive what assets and in what portion, based on whatever is in the estate. So it sounds like in your scenario, the primary residence as well as the medical malpractice proceeds are part of the estate that would be divided up according to whatever the Tennessee state statute is.
Okay,
Correct.
Great. So what would be – go ahead. Was you going to say anything, Rebecca? Go ahead.
No, I was going to say the same thing. This particular part is so specific to state law that it's hard to address, all of the states at once.
Yeah. Kind of figured so simply because of the fact different people different states may, have different, terms and conditions, regulations, and what have you. So that's the only thing that I can be able to grasp from is what the questions, perhaps maybe come to me and what have you. So good. So the next question is, what is the earliest age that a person, because we never like to think about sitting down planning. That's the last thing that we think about. We don't want to hear anything about any advance directives. People get afraid. They probably run from you if you say anything about that. So what is the earliest that an individual needs to sit down with the legal representatives to start planning for their future in regards to wills, testaments, different things like that? And that question is for both, and we'll start with Laura.
So I think now is the time to plan. I will say I want to specifically mention our adult children My son is 17. He'll be 18 in a year. When our children turn 18, they are adults in the eyes of the law, and they need powers of attorney. If you're sending your child to college, you're going to want to make sure that your child signs the waiver that allows you to communicate with the college or university. Because there are times that parents need to know information. And once that child is 18, we simply don't have it in the same way that, we have for the first 17 years or so. Mm-hmm. It also comes up with my special needs families who take care of their child, 24/7, 365, and then don't necessarily realize when that child is 18, you're going to need to go through a court proceeding in order to establish guardianship or conservatorship over that adult child. I think people should plan throughout their lives. Estate planning is not once and done. It is not static. There are obviously life and financial events that can prompt someone to plan, but I think it's a good idea to take a look at it on a regular basis because your wishes are going to change. Your relationships change.
Okay, Rebecca?
Yeah, I think Laura and I see this very similarly, and so we call it the baby estate plan when you turn 18. Every single 18-year-old needs a baby estate plan. So we've had clients where that includes the Advanced Healthcare Directive and the Hipaa waiver, plus the local state privacy waiver and the financial power of attorney. We've had clients whose kids have been traveling, pre-COVID, and they have gotten in an accident. And when that kid is in a hospital in another state and can't say, please, talk to my parent, that HIPAA waiver will prevent the doctors and nurses from talking to the parent to get instructions, to give information and get instructions on what to do. So the HIPAA waiver is what prevents the family from learning what's going on, and the power of attorney or lack thereof is what prevents the parent from making decisions, and it is terrifying. So we just tell all of our clients, we keep track of when those birthdays are coming up, and we say, hey, you need the baby estate plan. Most of them just want the free statutory versions, and so we just provide that and provide whatever, help they need to fill that out. Some of them want their kids to go through the experience of the attorney drafted, so then we go through the same very detailed experience that we do with the parents. But I think Laura's 100% right that at 18 you really need to think about that. And I say, not only if your kid's going away to college, do one in the state where the kid lives with the family, right? And also do one, a statutory one in the state, or if the school has a form, do that advanced care directive there as well. So the medical community is really comfortable with whatever that form is. So those are both super important. And then, the trigger for us in California is when you have real estate, because it's going to trigger probate, and our probate is way worse than it is in Georgia, because it takes a year or two. We've got to be the worst one in the United States. Wow. It takes a year or two to get through it, and it's a formula, but roughly 3 to 4% of the gross value of your estate. So you do not get to subtract a mortgage. And in California, real estate is outrageously expensive. So you could have hardly any assets, but you'd have this house and it's worth $1 million, which is, a dime a dozen here. And you could have, a $900,000 mortgage, and you're paying probate fees 3 or 4% on that $1 million. And half of that goes to the lawyer and half of that goes to the administrator. And so, don't pay lawyers more than you need to. Pay them what you should to just set up that trust in the first place. So like Laura said, assets change, wishes change, people change, the laws change. So we do maintenance meetings every 5 years or sooner if clients need them to make sure we've captured all of their current wishes.
Absolutely. And go ahead, Laura.
I'm sorry, Diane. I didn't mean to interrupt.
No,
I just wanted to piggyback on Rebecca's mentioning of the Hipaa document. Incredibly important, and I have had firsthand experience with that in the last year with both my mother and father. My father passed away this summer, but my mother has had some medical crisis as well. And the Hipaa document I was able to provide to the hospital and to the rehab facilities never had a problem being able to communicate, never had a question whether my sister or I could speak to the doctor, speak to the nurse, help make decisions and be involved in conversations. So I really cannot emphasize the importance of a Hipaa document. I can't overemphasize how important it is. Just for ease of family communication, helping your loved one, it's truly invaluable.
And this is also important. Also, I would like to say, which kind of came to mind, it's not just for those that perhaps maybe have a certain bracket of income. It's for everyone, even the entertainers. You know, after I sit back and I thought about some things down through the years, like I think Prince was one of them. He's an entertainer. He was an entertainer. Red Fox was another one that had an entire blow up about his possessions and what have you. There was nothing written down. Barry White was another one. James Brown was another one. And it's just kind of critical to make sure that you have things that are put away in writing, so people will not have disputes, afterwards, and then everything can kind of draw away a little peaceful. Because even, and I don't think I want to go into that segment, but it was just something briefly that I wanted to touch on. I think a mortuary was trying to collaborate with a power of attorney versus a beneficiary, and I'm like, okay, you are not trained in that area, because I wouldn't have thought about putting myself as a mortuary director in between those types of entities like that. They're two separate things. I would have dealt with the beneficiary first on this particular case, and then the power of attorney. I don't know where that would have came in at, is when it comes down to planning for loved ones, leaving this earth. That didn't make sense. So anyway, on to the next question that I would like to be addressed. There was an article that I read this morning, and so it was sad, of course. I don't know why this power of attorney segment is so sad, but anyway, the article addressed this individual. As Laura, I had explained to Rebecca last week that I'm also going for a law student as well. I'm in law school right now. And so criminal and civil cases is kind of more of my point that I would like to address, whenever I'm completed with that. So with the criminal side of it, there was a lady that ended up paraplegic. She's still living. And so the question came up in the article, and it hit the news also. That it came up in the article. And I don't know why Georgia is so, I don't know, I don't know what the word to use. I don't know why it comes to certain things, they kind of brush it off or what have you. But anyways, she got injured while she was incarcerated, and so she settled for a $4.6 million settlement. However, while she was incarcerated, somehow there was nothing down in writing as an advance directive or anything about how she should be treated. Her family was not informed. They did not let her know. The institution did not even allow her to get any information, in regards to any of those things. So it had to come to a point where she became paraplegic. I think she was abused by the officers. This is on the news, national news. She was abused by the officers. And so what had happened was they was like, okay, we're going to call the Senate. But you can't call the Senate after you'd have made a settlement. Is that correct? That can go for either one, Laura or Rebecca.
Can't call who?
I said that's for either, the question is either for Rebecca or Laura.
I know. I think we're both a little fuzzy on what the question is. The person.
Okay, and so the question was...
I understand that there was a settlement and she's a paraplegic, but then...
Right, and so the question was, there is no other legal authority beyond the settlement. Is that correct? After you make to my understanding, I thought that after a settlement has been made, you cannot go back and say, well, we're going to sue this person, or we want the officers arrested, or we want the institution tried to have a trial. We want them to be accused of doing so and so and so and so. And due to the fact that there was nothing written down, she's still living, but she's in a vegetation state or something like that. But there was no legal documents written down. I guess that's the question. I'm sorry if it's confusing.
So
she would have to be conserved.
Right. That's what I was going to say. There would have to be court supervision of that settlement if she did not have powers of attorney in place before she became incapacitated.
Oh, that is just tragic.
It is tragic, and I'll, if I may, and I know, Rebecca, you've seen this in your office as well, kind of the day-to-day tragedy is the family who calls us after their loved one is incapacitated and not able to find documents. You know, we get calls all the time. I need to bring my mom in. I need to bring my dad in to get a power of attorney. And once we've met with that person, they're clearly incapacitated, don't have legal capacity in order to sign legal documents, which means we have to go to court. And nobody wants court in the middle of their day-to-day family decision-making.
Yeah, it's hard enough to just care for someone who's incapacitated, let alone have to deal with the whole legal battle and drama.
Okay. Fair enough. So we've already discussed that it's important to start, I guess, when you become an adult, as to when an individual needs to sit down and start planning on their estate, even though individuals do not want to. I'm still trying to work on some things, even with mine. And then we've also just shared and discussed about intellectual properties, which I think is very, very important, because I think it reduces a lot of confusion after a loved one has become sick, or after they perhaps maybe have passed away or what have you. And I also feel that it's important to sit down and write wills and get more general information as to what to do and how to be able to go by doing it. So this is going to be another question in regards to documentation. A lot of times when it comes to advance directives, and I have done it too, we go to online. So how effective are the online documents? Because at the end of the day, as I explain to these guys and to other individuals, that you still have to pay. There has to still be some kind of appropriate fund that you have to pay even after you print it off or what have you, in order to be able to get it, legalized and notarized. And so that's another question that I would like to address. Even though it says free and it says download, at the end of the day, I still always advise individuals, still go and get you a legal attorney so they can make sure that things are appropriated the right way. It kind of is a little difficult to be able to do it on your own, and you're the only voice, and you don't have any legal terminology as to what's going to occur and what's going to happen. And that's another thing, as I stated, I always talk to these guys and tell them it's best to go in and get the full durable power of attorney, and then too, it's best to get it from a legal agency, and that way it will be more effective.
Well, I have
Anybody?
lots of feelings about this. Excuse me. So in all, transparency, this has been something that has really impacted me over the years that I've been practicing, because I see so many people who go on these websites and they create these documents that are so detrimental in the long run, right, because they don't know. So I am launching, separate from my law firm, an online way to do this that will actually work with the proper education that is launching on Valentine's Day. But aside from that, what I tell people is don't pay to go on some of these sites. Just download the statutory version. If you can't afford a lawyer, download the statutory version that your state has created. So if I go to the Los Angeles government website or I go to the California government website, I can download a statutory durable power of attorney for finance and the statutory advanced health care directive. These documents will work. There are no nuances. There are no details. There could still be ways that you could fill it out wrong, but the document will work and it's free, versus going to some website and you have no idea if it's going to work or not. In California, and I don't know how it is in Georgia, Laura, but in California, the Advanced Health Care Directive does not need to be notarized. It just needs to be witnessed. But but by the probate code, the durable power of attorney must be notarized, which is a $10 fee. So there is nothing stopping every single person listening and every single person who's over 18 in America to go and fill these documents out and pay $10 to get, or maybe $20 if the advance directive needs to be notarized, and you are done, and it is a gift you give your family.
Okay, great. Okay, Laura?
Totally agree with everything Diane just said. These documents are gifts, because what you're really giving your family, it's not the documentation, it is the framework within which they will either help you make decisions for you, or carry out your wishes once you're gone. I also have a lot of thoughts and feelings about online so-called legal documentation service providers. The most challenging, difficult, and tragic probate situations I have handled in my office are because people did their documents online. And those documents don't say what either the deceased thought they said, didn't cover a special needs situation, for example, didn't disinherit somebody who really didn't need to be in the picture. They can be a mess when it comes to wills and trusts online. They can just be a mess.
Absolutely. And I mean, I can't tell the next person how to be able to plan their estate, wills, and trusts and what have you. But it's very important to get started on it early and make sure that all the I's and the I's are dotted and the T's are crossed to make sure that all the information is, and that's the next question that we have before we get ready to wrap up the segment, and that's when we go and get to the part where after the will is read, and so about the bequeaths and all of that, and it's something how when the person gets to the, and I've never been in this situation before, but I've seen a lot of stuff. I watched too much of Columbo and Peter Falk. And so it is something about when they get to the court and it is read and the individual that has prepared the will has not even advised the rest of the family or other certain family members or certain friends or certain neighbors as to them being included, in the will and testament. And so when they get there, they're shocked and surprised. The only thing they know is they're supposed to be able to come. So could both of you, from on both sides of the perspective in Georgia and California, be able to share with the audience as to how just kind of take us through a little bit of how the will and testament operates, and then when they get ready, the process of when they get ready to go to court, what to be able to expect on that behalf as well. Because even with the situation with the medical malpractice, with the medication, with the not the medications, with the pharmaceutical, the individuals that were involved in that scenario did not even have to go to court, but the finances or whatever that came after were issued out to the wife and to the children. So if both of you all can be able to share a little bit about that, and that can also kind of take the ease off of individuals, because sometimes people be afraid when they go to court, don't know what this will is going to say, don't know what this testament is going to say, don't even know if I was even included in it. And some people are not even aware that they're included in the will until afterwards. So could both of you all kind of touch on that topic a little bit?
I'm happy to go
Laura,
first, but I jumped in on the last one. So, Laura, go ahead.
Okay. So there are a couple of different concepts that I think are being brought into this part of our conversation. Under Georgia law, when probate is filed, and that is whether there is a will or if there is not a will, there are certain people that have to be notified. So the heirs at law are the people who have the legal standing and the legal right to inherit from your estate. And those people have to be notified. That is by law in my state. Those people may be different than the beneficiaries. And so the beneficiaries are the people that are listed if there is a will. So a real common example, married couple with a younger child, they are probably going to be each other's beneficiaries if one of them survives. The child is still an heir. It's going to necessitate some additional probate proceedings because the child is underage, even though it is the surviving parent who is the only beneficiary. So there is a distinction between those two things. Once the will is entered for probate, then it is the responsibility of the executor or the personal representative, is the legal term in my state, to notify those beneficiaries and carry out the wishes of the decedent.
Okay, not the attorney. It's not the responsibility of the attorney to do that.
Not necessarily. It's really the person who has been sworn in by the court as the personal representative. And of course, people are free to hire attorneys and get expert help through that process.
Okay. Rebecca?
Yeah, it's, when you were explaining this scenario, what came to mind is what you see on TV, where you see usually it's a white guy, right? Some white guy, middle-aged lawyer who's like in this big conference room with a lot of wood, and it's the reading of the will, right? And that's only happened one time in my career where, like, people wanted this kind of ceremonial event, right? And so normally, I'm sure Laura is the same. We do a lot of trust administrations, and there's nothing involved in court. And so it's the trustees or the beneficiaries who are hiring lawyers to figure out how to do this. Now, the trustee is the one who is administering the trust, essentially, but sometimes there's conflicts and issues, and so beneficiaries will hire lawyers too. But in terms of, it's similar here in California. You're essentially notifying two layers of next of kin. Whether these people are close to you or not is irrelevant. Whether you haven't spoken to these people in 30 years or maybe even never met them if you don't have children, they will come out of the woodwork, right? And so we want to avoid that at all costs, because clearly if the decedent hasn't had a relationship with those people, that's not who they intend to leave their assets and estate to, right? And it could go to friends or charities or whatever. So, but the process is somewhat similar to what you described. Laura, here in California. But I just want to distinguish between what happens when you have a trust administration, which is completely private, to if you don't do planning or if you only do a will, that it's going through this court process.
Okay, great. So here's the last question for both attorneys. So, Laura, we would like for you to be able to leave 3 tips or resources that you would like to leave with the audience in regards to our topic on today, advanced directives, whether it's power of attorney or, planning state wills and testaments. You can be able to do that at this time.
So a couple of recommendations come to mind. I agree with what Rebecca said earlier. Every state is going to have a publicly available resource for powers of attorney. Obviously, a lot of my client base is referral based. So if you have a friend or a loved one who is used an estate planning attorney, that's always a great place to look for a recommendation. I think I would like to leave your listeners with a word of encouragement. Most people have involvement with attorneys because they got themselves in trouble or they went through a divorce. That is kind of a typical experience that people have with attorneys. And so sometimes when people are coming to talk to me, talk to Rebecca, they have maybe a negative experience in their past or in mind or something they heard from their friend. And people are very hesitant to talk about these very personal and intimate issues. That's what we're here for. I mean, I am there to sit at the table with you and talk about the good, the bad, and the ugly. And my job is to facilitate those conversations and make sure that the client knows what his or her choices are and is making the best decision they can based on the law, based on their wishes, and how we can most effectively carry out those wishes. So, word of encouragement, we're not scary. These may be difficult topics, but we are well-versed in dealing with those. I mean, that's really at the heart of what we do every day.
Okay. Rebecca?
I agree 100%. So I wanted to touch upon a few different things that we haven't really talked about, but that are big tips.
Sure. Go ahead.
One is when you're creating this power of attorney, and I don't mean for 18-year-old kids, right? They're putting their parents usually in roles of agency for them in the documents. But when you are, older and you have more stuff or more people in your life to choose from, picking the right person to serve as power of attorney or advanced healthcare directive agent is really, really critical. I would always recommend picking one person and then a successor and not picking 2 people together. These form documents can't address any conflict resolution that may occur. And also we're finding, I don't know if you are in Georgia, Laura, but we're finding that financial institutions on the power of attorney side are not accepting co-agency anymore when you pick 2 people to serve together. So pick one person and then the other. Make sure that they, for the power of attorney, that it's someone who's good with money and pays their bills and is responsible and responsive, right? You don't want to pick someone who's in financial need. It can create a mess. And then on the advanced healthcare directive side, really make sure that the person will honor your wishes and put their needs and wishes aside and will advocate for you. And then the other issue that comes up is where to keep these documents. So I always tell people, give the advanced directive agent to the person you would want to step in so that they can do that really effectively and immediately. But I don't give that power of attorney for finance out. I keep that in a safe spot. For our clients, I tell people, you tell the next in line to come to us when something happens. I want to know that something's happened. But I think for people out there filling out forms, keep that one secure because that can be a mess. And then finally, just as a word of advice, don't add people to your accounts or to the deed of your property willy-nilly. you want people to be of service if you lose capacity. You don't want them to own something equally with you. So oftentimes people will say, well, I'm just going to, it's an elderly person, I'm just going to add one of my kids to that bank account with me. But they don't realize that they have just made that person co-owner who could take all the money, or if they get in an accident, the PI attorney, personal injury attorney, can go after that money as the kid's money. Or when the person dies, it automatically becomes that kid's money, and that can really disrupt family harmony. So be very careful in these areas. And, of course, we have so much more to talk about, and we always run out of time.
Yes, and very, very briefly, Rebecca is spot on what she describes about real estate and bank accounts. This is inadvertent estate planning and often does not end up the way people think it's going to. So here to that piece of advice.
Okay. Back to Rebecca. We want you to be able to give them what they need. If there is something, if there are a few more tips and things, we got a few more minutes left. There are a few more tips that you would like to add. Of course, we would love for you to be able to add, because even though this is as Laura had stated, this is a critical topic and what have you, but it's much needed to be, discussed and shared so individuals will know on a legal standpoint instead of them assuming. That's what agitates me.
Right.
I don't want people to assume. I want them to know. So go ahead.
Yeah, I think it's really important what Laura was saying. People have a negative opinion of lawyers until they need one. And that's because there are a lot of bad attorneys out there, just like any other profession. People who are in it for the wrong reason, people whose ego gets in the way, people who are in it just to make money and they don't care about their clients enough. But there are so many of us, and I can tell Laura is one of them as well, so many of us who really want to do right by our clients, and it's being of service. So when it comes to estate planning, don't go to just any Joe Schmo attorney who says, oh, yeah, I can do that for you. Find someone where this is their specialty. And I analogize that with, if you had a heart problem, you're not going to your primary care doctor to solve your heart problem. You're finding a cardiologist. And lawyers are just as specialized as doctors are. And so it's really important to find someone who does this, practices this pretty much exclusively and is very knowledgeable, and that you connect with. This should be a lifelong relationship so that you are really comfy. When we have clients come to the office pre-COVID, we have a living room setting. We don't even have a conference room setting except for when we're signing documents and you need a hard table, right? But it can be a wonderful experience. And like Laura, I can tell, part of it is therapy. We have a tissue box in there. These are hard subjects to talk about. And so we want to navigate that, because ultimately the most important thing is that you get your wishes honored and that families maintain harmony. And if you don't handle these affairs, people fight over the dumbest stuff. I once asked a probate judge in California, I was at an event, and I said, and this pains me to say part of what I'm saying, who's fighting more in probate court, men or women? And he didn't even take a breath and said, oh, women, hands down. And I was like, damn, I was afraid of that. And then I said, what's the smallest amount you've seen litigated? Now, when I say litigated, I don't mean it's just going through the probate court process because somebody didn't plan. I mean they are duking it out with lawyers, fighting, paying crazy amounts of money. And he said over things that might have a $10,000 value. So obviously their legal bills far exceed that. And so people fight over, grandma's salt and pepper shaker. They fight over things that shouldn't be fought over. So if you are with the right attorney, you'll talk about these issues, you'll sort it out, you'll identify all the little things that people care about. We ask our clients, I want you to go to your kids. You tell me they don't care about any of your stuff, which might be true, but I want you to go to each one of them and say, is there anything super special to you? Because I want to make sure that's a specific gift. So that's my last piece for now, I think.
Wow, absolutely. Because with both comments that you all had said, it's very important that individuals do their research. I mean, I can write down tons of names right now of certain individuals that have taken just totally tens and $20,000s of dollars, and so they'll be crying on this particular platform, and they're looking for another attorney. And I'm like, wait, you just paid $20,000 and he didn't give you, or she didn't give you exactly what you did. And especially the immigration community, they are really the worst tribe that is taking advantage of, where they have spent out tons and tons and tons of money to attorneys that they trust and what have you. And so on this show, that's the reason why we make sure that we do our research to ensure that the audience has the best quality, the best resources, the best tips, the best the best information and knowledge, so they don't feel that they're taken for a Ferris wheel ride or a cartwheel or whatever and what have you. So I think that is very, very important for individuals to do that. And so I think there was a discussion that came up about a couple of months ago, well, why don't they put reviews out for attorneys? And I think that there is a site, AWWO or something like that, where they do list the attorneys. It may not be their images or what have you, but they do list, testimonials that may come from that particular office or what have you. So it's just a lot of things that some individuals are trying to present to their local aldermen and what have you in regards to that, making sure that they are getting the right representation. But at the end of the day, they're going to have to do their own individual research to make sure that they can look at other trials or cases that individual has tried, whether it's criminal or whether it's wills and testaments. It doesn't matter what it is. You still can be able to do your research and be able to get the most effective information and results from online. So I kind of sympathize with family members and loved ones that have to go through that, and then they're taken for a ride, 15, 20. I'm serious. I'll be listening to it every day, just every day, $15,000, $20,000, and then, I did not get what up, and then so it was another discussion that came up, well, I'm going to get my money back, and that's when I went in and told her, I said, no, you can't, just because he lost, you can't go in and get your money back, just because the attorney did give you what you thought that he was supposed to give you in that trial. So it's kind of sad that they're taken for a ride like that, and that's the reason why we try to make sure that we have the right representatives and experts on our show to ensure that the audience is safe with our people. So here is an opportunity where the audience can be able to connect with you as a guest. You can be able to share, and this is for Laura and for Rebecca, you can be able to share your website, where they can be able to find you, any social media links that you would like for the audience to be able to follow you so they can get a little bit more understanding and kind of follow you down through the journey as you take your journey through the legal path and what have you, and then they can also be able to connect with any books that you have written or any upcoming speeches, which attorneys need to have that too, where they're addressing things in the community, so people can be more and more aware. So you can be able to do that at this time, and we'll start with Laura on that.
Thank you so much. I really enjoyed our conversation today. I appreciate both of you. So my law firm website is www.frenchlawgroup.com. And again, I am located in Watkinsville, Georgia, just outside of Athens. Like Rebecca, I have some other things rolling out in the first of the year. My other website is themomlawyer.com, and I have created a training program for attorneys in this field, specifically focused on women who own their own firms. So if there are any professionals who may be listening to this, I would love a chance to work with them as well. Again, I encourage your listeners to take care of this business. Most of my clients, when they leave the office, say things like, I feel such relief, this was a lot easier than I thought it would be, thank you for taking care of this. There's just a real sense of not just relief, but also empowerment that you've taken care of your adult business. So I encourage your listeners to do that as well. So thank you again, Diane, and Rebecca as well. It was great to meet you in the cloud here.
Mm-hmm.
Yeah.
You're welcome. Rebecca?
Thank you. Yeah, thank you, Diane, for having me back. And Laura, it was so good to meet you. I'm going to connect with you outside of this because we get people who need lawyers in Georgia, and I just want to be able to send them to you.
Likewise. Thank you.
Yeah. So our website is goldfarblou.com. So GOLDF like Frank, ARB like boy, LUU.com. All of our social media is on there, and it's just been such a wonderful opportunity to get to know you better, Diane. And I do have some follow-up stuff on all the prisoner stuff, so I'm going to be in touch with you on that.
Okay, great, and thank you so much, Rebecca, for coming back to be with us on this week, and thank you, Laura, for being our guest on today. And we have changed. We are Women Who Rock with Success Media at this time, and we are so excited because we can be able to feature those that have been on the show as well. We can't feature all of them. Since we have started the podcast, I think we've kind of went up to like 300 or 400 women, but we try to pick out the ones that can be able to help our audience to be able to grow, and those who visit our site. So you can find us at www.womenwhorockwithsuccessmedia.com. So ladies, thank you once again for your expertise on today, and everyone have a wonderful day.
Bye-bye.
Bye-bye. Thank you.